Now, the South African Law Reform Commission is undertaking a major review of the Criminal Procedure Act, aiming to modernize as well as reform the country's criminal justice system. This review is expected to create a justice system that is fair, efficient, as well as accessible to all. Veronica Makhoali has more.
Giving a media update in Pretoria, Deputy Minister Andries Nel, joined by members of the Justice, Crime Prevention and Security Cluster, outlined some of the key areas under review. These include arrest procedures, bail regulations, alternative dispute resolution, and increased participation of victims in legal processes. The review by the South African Law Reform Commission will also look at the use of force in arrests. Authorities will examine how unnecessary and, at times, unlawful arrests contribute to high litigation costs against the state.
The Commission is also proposing amendments to Section 49(2)(b). This section provides that an arrestor may use deadly force if a suspect is suspected of having committed a crime involving serious bodily harm and there are no other means of effecting the arrest, whether at that time or at a later stage. The recommendation is that Section 49(2)(b) should be repealed as it could be considered as authorizing extrajudicial killings. If you analyze the wording of this provision, you will note that it permits the use of deadly force without requiring that the suspect should pose a threat to the arrestor or any other person. Also, the commission of the crime does not have to be within the personal knowledge of the arrestor. In fact, there is no requirement for the arrestor to personally believe that the suspect was involved in the commission of the crime.
Another key focus is the bail system. This comes amid concerns about overcrowded correctional facilities and lengthy pre-trial detentions, often caused by accused persons who cannot afford bail or lack a verifiable address.
Considering that the perennial problem of overcrowding in correctional facilities and lengthy pre-trial detention has been attributed, among other things, to the lack of verifiable address, physical address of accused persons, unaffordability of bail, and the implementation or application of the current statutory framework relating to bail, in particular, Section 50, subsection 6, paragraph D, and 342A of the Criminal Procedure Act have been identified as some of the provisions that have contributed to these problems. The Commission proposes that proscription of pretrial detention for certain offences, that the courts be empowered in appropriate cases to release indigent accused on own cognizance.
The Commission has released discussion papers for public and legal input, with a deadline at the end of March. This will be followed by a public consultation process to shape the final recommendations. For Newzroom Afrika on Channel 405, I'm Veronica Makhoali in Johannesburg.